today being the last session of our AIPR program. And it was nice that you all attended all the sessions and you have taken the best of what the IPR course can give you. And the materials and the PPTs and other things were shared. You have all worked on the assignments. So that's a pretty good thing. We had one last segment called the sector specific IP, right? If you have gone through the sector specific IP module, you will find that we had sort of brought the intersection between IP and various other industries like entertainment, what happens in the entertainment media, what happens in the healthcare and pharma sectors, and also in the software and IP areas. These are some untraditional knowledge, of course. And so these were some of the areas that we had touched upon. Now, when we talk about intellectual property from different industry perspective, they have some interpretation. So it's like if you say the Patent Act or the Trademark Act or whatsoever it is, the enactments, rules, regulations, etc., that is standard for all of them. But how each of the industry adopts these forms of IP is what matters. So here I have a quick small presentation for you. So I don't know if you've been hearing of instances where AI has been playing a major role, and this is one of the bands, music band. It's called Velvet Sundown, and they release certain albums. Now, what was special about this album was the music, scores, background images, everything, right from composing a music to the lyrics of the song to the entire production of this album was AI generated. This was the first of its kind, perhaps, where they had the entire thing. They have come up with a complete album which is AI based. So this is something which has been happening. And now the listeners were not very happy about it. They said, oh, it's an AI generated. We did not know about it. So they were also, music insiders, that is music companies and others, they have been saying that the listeners should be warned that this is an AI generated music, right? Or an album. Now, this particular band, they became very popular because they got something like a 1 million plays, 1 million hits on Spotify, which is why they sort of they became popular overnight. There was nothing in their backgrounds, like there were no previous albums, there was nothing. All of a sudden, this particular AI generated band became famous overnight. So, which is why there was a sort of a hue and cry in the music industry saying that if there are AI generated music or content of the sort, they must be warned of, the listeners must be warned about it, that it is AI generated. So, that is one instance. There have been many other instances like, I don't know if you've been hearing of an AI generative tool called Claude. Claude basically it sort of summarizes and it has the potential to bring about. It's just like your chat GPT where you give a particular content or something and it tries to crawl around and bring you a lot of content. Now, basically, this was a company called Anthropic. I don't know if you've heard about Anthropic. This is Anthropic's copyright issue which had come up. So what happened here was Anthropic, for the purpose of training its model, that is the Claude model, had been taking certain pirated books. They had been using certain pirated books and the digitized copies of the pirated books, and they were training this model. So this came up before the court, okay, by Meta was the company which had filed a case against them. And the US courts in this particular case mentioned that AI training may be fair use. You may train the AI, okay, with a lot of content and other things, but using pirated books was not allowed, even for the purpose of your trainings. So that is the copyright issue here. The firm held more than 7 million pirated books in a central library. There was a particular firm, and Anthropic got into an agreement with that particular firm to train its Claude, that is the AI tool. And Anthropic's defense was that the use of books at issue to train, it was only for the purpose of training Claude, and its precursors were exceedingly transformative. So that is where that was the defense that they had taken, and therefore they said it's a fair use. But however, this was not considered, the US courts did not consider so, and finally Anthropic had to enter into some kind of a copyright settlement, infringement settlement, for about 1.5 billion with that group of authors whose books were pirated. So they had to pay something like, and there were like thousands of authors, so they had to pay a fairly decent amount to each of these authors for on the grounds of settlement. So what was held in this particular case was that the fair use doctrine enabled copyright works to be used by third parties without the copyright holder's consent, like illustrating a point in a news article, etc. So AI companies trying to make a case of the use of copyright work as in terms of training their generative AI models have to invoke fair use. So, but the authors and other creative industry plaintiffs have been pushing back. So they are not very much for pirated matters, pirated copyrights. So basically, this settlement sort of sent out a powerful message to all the AI companies and all those creators that taking copyright works from pirated websites was wrong, and you have to be extremely cautious about where you are procuring the data to train your models. So this was another case that had come up. I'm just trying to explain some of the instances that have been happening internationally in the context of IP in the digital space. Okay, there was another case. I don't know if you've been hearing of Otter. So it's been a very common practice that whenever there are meetings that are held, right? So in order to transcribe the meetings and to summarize the meeting, to create minutes of the meetings, all these are happening today in a fraction of a few minutes through the use of AI. Otter.ai is one of the tools, which is one of the AI tools, which is being used for the purpose of taking conversations and transcribing them. So, but what happened here was there was a case against Otter AI in California before the California court, where it said that the Otter note taker secretly recorded private conversations on popular platforms. So, Otter did ask for consent for the video recording, right? So for now, suppose if I have to set the video recording, it asked me for the consent, but it did not ask the participants for a consent, right? Those who are participating in the meetings, they did not know that it was secretly recording the conversations on popular video conferencing platforms without the proper consent. So suppose I have been using Zoom. Back end of Zoom, Otter was already transcribing. So this also had to be mentioned. This also had to be told to the holders, account holders. That is the reason why Otter has been in the news. And there is also another, this is something to do with patent. So all this while we spoke about copyrights and mostly copyright related issues, but this was one of the patent issues which you will find on the WIPO magazine. It's a battle to own there's something called the gene editing tool. Okay, it's the CRISPR, and CRISPR stands for clustered, regularly interspaced, short palindromic repeats. Okay, so this was basically a defense mechanism. It has been a technology where it is a natural defense mechanism which allows bacterial cells to detect and destroy virus that attacks them. So there are certain of these defense mechanisms that have been identified, where there is a huge scope in terms of improving and understanding human and animal diseases and their treatments. This is one of the major innovations, I would say, in the area of gene editing. So there has been, this again has been a subject matter of dispute between the University of California and Broad Institute in terms of the ongoing priority dispute. So who has the priority over the competing invention is what has been in the news for quite some time now. And then this was about Tesla. Again, when you talk about data protection, right? Data protection in the digital age. So Tesla had sued some of its employees because they had been, some of the ex-employees had taken away their data, some critical data of the company, and they were trying to make use of it. They were trying to sell it out to third parties, which is why they had sued these former employees against alleged data breach. So that was another instance that we had seen. This is another trade secret dispute where, again, certain former employees of a company, that is Fitbit, okay, they indicated that there was another company called Jawbone. Again, they were into smartwatches, and they had sort of copied a lot of the intellectual property. They had infringed upon a lot of the intellectual property of Fitbit, and they were trying to use it on their devices. So again, this turned out to be another form of a trade dispute. So these are some of the illustrations. These are some of the case laws that I just wanted to bring about, just for us to set the context to understand the legal aspects of IP in the digital age and what are the challenges that we have been facing. So why IP matters in the present digital economy, right? Number one, definitely value creation. There are a lot of innovations and incentives, and today we are talking about so much of disruptive technologies which have been coming in, and they have a huge potential to improve the digital economy. It is very competitive again, thanks to the AI, and there is much more competition in the digital age. Trust and protection. So for any of us to trust the commodity or to trust a brand or whatsoever it is important that we protect the IP in the digital age. Monetization, apparently all IPs, whether it is in the digital economy or even otherwise, the very purpose of IP is to monetize, manage risks, especially of of piracy, counterfeit, and various other things, and new frontiers. So explore new frontiers of technologies, and in order to do that, they need to protect their IP as well. When we talk about the transition from physical assets to digital assets, so perhaps what was books earlier is now ebooks. What was music earlier in the form of CDs is now e-music. And we had patented machines, and today we have them in the form of cloud-based inventions, gaming, software products, metaverse, and these are some of the things that we've been seeing as digital assets which the companies own. What has been the impact of internet, AI, blockchain, social media? We've been talking about all of these things. So what has been its impact on intellectual property? After the internet came in, it made distribution instant and global. So if I have authored a book, and if the book is digitized, it is instant that it can go all across the world, right? But what did it also do? But also made infringement faster and harder to control. It is quite difficult today with the internet itself to allow to stop infringements, right? So that is where we have a lot of DRMs, that is digital right management tools, which try and protect us of IP infringements. Then we have AI. Today, what we are experiencing in the form of artificial intelligence, it raises new authorship ownership questions. Now, who owns the IP if the entire music album is AI generated, right? So one of the arguments being that since they have put in a lot of skill and effort to come up with the production, they own the IP. But AI can do much more than what I even asked for. I may give certain prompts, but it may do something even better than what I have prompted, right? So these are the questions that are commonly raised in the IP from an IP perspective. So the most important question being, who owns the AI generated works? Then talking about blockchain. When it comes to blockchain, it enables NFTs, that is non-fungible tokens. That's what we call them as. This is one of the new mechanism that have come in. They are also like sort of currencies, and non-fungible tokens and smart contracts are very much popular today. And again, they have all been creating questions of who owns, creating new ways to prove ownership of digital goods. So who owns these? Because blockchain is a huge thing. It's massive, right? So who owns these NFTs, or how do they own it? How do you determine ownership in all of these? All these becomes the question. And of course, social media. A lot of things have been happening on the social media. And the issues here being, the impact here being, there is rapid content creation and sharing. That's what we have been doing. That is the good thing about social media. But memes, viral posts, they all blur the line between what is a fair use and what can constitute infringement. We've been seeing a lot many cases which have been showing up in terms of infringements, protecting the publicity rights of celebrities and various other things as far as the social media is concerned. So these are some of the challenges that it is posing to us. Okay. So that's about it. And then challenges, coming to the challenges. Copying is very easy today. Digital file can be cloned endlessly at zero cost, right? That's the biggest challenge that we are facing. Piracy, streaming, and P2P sharing platforms fuel massive copyright violations, obviously. Anonymity, infringers hide behind fake accounts. We are experiencing anonymity to a very large extent, making enforcement very difficult also. We don't know who the person is for me to even send out a legal notice. Cross-border issues, laws differ from different countries, and what may be legal in one country may be an infringement in another country. Like, for example, something like what we are seeing here in terms of parody, right? So I may just call it a parody, and some countries may just not consider it. It's just a funny version of something. So some countries may not take it very seriously. They say it's that we have a broader fundamental right to speech and expression. So these are some of the challenges that we have been also facing in the context of IP in the digital age. Talking about software patents, so if you look at the provision of Section 3 under the Indian Patent Act, it very clearly states that software program per se is not patentable. But when we talk about software patents in the present context or algorithms in the present context, it is not just an algorithm, or it's not just a source code, but this technology is doing far more many things than what we even think of. So software patents today or AI innovations can be in the form of algorithms, apps, business methods, abstract ideas versus technical solution. That is what we need to identify. The case that I have mentioned here is a very important case from the standpoint of what can be patentable as softwares. Okay, so this is Farid Alin versus Union of India. This is a 2019 judgment. This I will quote unquote the same thing because this is what tells us what computer programs can be patent protected. It says the bar on patentability. Supreme Court in this particular case held that the bar on patentability only applies to computer program per se, not all inventions based on computer programs. So they also emphasized that considering computer programs as non-patentable would be regressive. Today, we cannot still consider the same thing. What we had of computer program per se was in the year 2005, but today we cannot still consider all those in the strict sense. So given their significant role in the modern devices and technologies like as simple as ovens, automobiles, refrigerators in our households, okay, the court further stated that an invention can be eligible for a patent if it demonstrates a technological effect or contribution. So basically, so far as there is some technical solution, it has given you a technical solution, even if you call it a computer program, but if it has a technical solution, we can still consider it as a patentable subject matter. So that is what has been decided. That is what has been held in this case of Farid Alien. And this is taken as a benchmark case, a very important case in terms of determining whether software programs are patentable. Dabas AI inventor claim. This is another very interesting story about Dabas being an AI, right? Like Claude or generative, like how you say ChatGPT. Does ChatGPT own the IP? That's like the question. So in this particular case, the inventor, that is Stephen Thaler, had invented an AI generative invention called Device for Automated Bootstrapping of Unified Sentences. That's what he called it as Dabas. And he named Dabas itself as a new inventor, right? And the patent application was filed. Of course, this application was refused in jurisdictions like US, UK, Australia, etc. And the justification that the patent offices had was that in the USPTO, they said Federal Circuit case law on inventorship requires that the invention must be by a natural person. They were very clear about it. If you look at USPTO, the UK patent office, they said there is no evidence that UK law is currently inappropriate to protect inventions made using AI. They are sensitive to concerns like unilateral change, risks of being counterproductive, etc. So they have considered thinking about AI as one of the inventors, but not right now. However, South Africa is a little different on its thought. So the South African companies and IP Commission, they accepted this particular invention, this particular AI generated tool, that is DABUS, as an inventor. So they have accepted this application, and in July 2021 they released a notice of issuance of patent itself. So DABUS is the first patent generated for an AI invention. Okay, so that itself owns the IP in South Africa. So these are some of the things that we have in the context of patents. Then coming to trademark in the digital space. So usually what are the concerns we have when we talk about trademark infringements in the IP in the digital age? One is domain name, right? So obtaining domain name or similar domain names, etc. Cyber squatting or typo squatting. I don't know if you've heard about it, but if I know a very well-known brand, like maybe Maruti Udyog, right? They are a very well-known automobile brand in India. And if I copy a similar name and I call it as marutiudyog.in, and I don't have any intentions of using that mark, but I just wanted, in bad faith, in all bad faith, I take the domain name, and when Maruti Udyog approaches me, I sell it back to them, or I say that I want a particular amount. It's like some kind of a ransom I claim from them to just give back their own domain name. So this is what we call as cyber squatting. Online branding and trademark dilution. This is very, very rampant. Social media, influencer marketing. These are all some of the other issues that we have all been facing in the context of trademark and trademark infringements, or identifying the right kind of a trademark. The last aspect being copyright concerns in the digital age. So what are the copyright concerns we have? So the digital works, most of them are digital works today, or rather a lot of content comes in the digital form, like ebooks, music, film, software, digital art, etc. The common concerns being piracy, peer-to-peer sharing, streaming services, etc. Some of the other issues that have emerged are memes, user generated content, AI generated works. So we really don't know whether we should be having a copyright to that at all or not. And moreover, like what we saw of the album, the Velvet case, we really don't know if the entire thing which is AI generated should even be granted a copyright at all or not, right? So these are some of the issues that we have been facing in the context of IP, intellectual property in the digital rights space. These are only some instances that I have quoted of the more recent times that we have been seeing and experiencing of protecting intellectual property in the digital times. So this is a short presentation from me. I'll just close it for now. And if any of you have any questions, I'm happy to take them. Any questions? I hope this was useful to you.
Very useful, ma'am.
Okay. So, anything else that you have as questions or you want to add to it?
No.
Okay. Okay. All right. So, all right, then I think with this, we sort of come to the end of this program, this course on advanced AIPR, advanced intellectual property rights. I hope the live sessions were useful to you all. We have made our best effort to get the best in the industry and in the profession to talk about different subjects and, try to bring the best knowledge possible in terms of the program. So I hope the course turned out to be useful to you all, and we have met the key learning objectives. So just continue with your assignments, project, and there's going to be one exam that you will take around, I think, October 11th, 10th, I think is the exam. There's going to be a short exam. It'll be mostly case-based, okay? Just like, maybe a caselet that is given to you and you have to identify certain things. That will be more practical application for you all. So just prepare yourselves on all of these, go through the reading material that we have provided to you. So everything will be around that. Yes, Saidi.
Madam, some questions. First question is regarding completion of all the assignments which are available on the portal. All
Right.
are completed. Some I suppose only two or three are remaining. These
Okay.
live assignments,
Yeah.
those have to be evaluated from your side,
Yeah.
and IP infringement, those will be completed.
Okay.
After that, what about the exams? When will be the exams starting? Will
So I
be
told you, no, October 10th, you will be, it's also going to be an online exam. And October 10th evening, they will upload the question paper. You will be given time on the 11th. By 12th evening, you have to submit that answer paper.
October 11th, the question paper will be given and
10th,
huh?
10th, it will
10th.
be live. The question paper will be live. Dr. Anshul will keep communicating with you all.
Okay,
Just
communication will be there.
Yeah. Did you just keep observing or just keep, keep track of your emails and messages?
WhatsApp.
We'll keep writing to you all. 10th evening, the question paper would be uploaded. 11th and till 12th evening, you will have the time to work the answers and you can submit it. Even again, submission will happen online. We will evaluate it and we will share the details of your evaluations and other things in just some time. In about 15 days or so, we will be sharing all that with you. And the certificates will be distributed.
15 days the results will be out.
Most
In
probably.
15 days the results will.
By end of October, you should have your certificate, is what I'm thinking. All right.
Okay, ma'am. No issues. Any research work available in EBC?
Not as of now that I know. I really don't know of what are those. I don't really think there are any research works as such available, Saidip ji. If there is something, I think they will call for or they would let them know. Right?
Okay.
Because they are publishers. They allow you to publish books. They don't do any research by themselves.
Yeah, even allowing to publish book is okay. I will
Yeah.
do it.
Yeah. All right. So, okay, all the best then. Thank you.
Thank you, ma'am.
It was nice interacting with you all. And thank you, Deepak ji. You
Yeah,
sat
thank
through
you.
the entire session once again.
Yes. Thank
Okay.
you.
All the best and yeah, happy festival.
Thank you. Thank you.
Thank you. Bye.